We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Schultz Law.
Hi, we are Legally Sis. I'm Attorney Wen.
I'm Attorney March. Welcome to our podcast. We have started this podcast in March,
Think so.
and since March 2023, we have been receiving a lot of inquiries from our viewers through the website, our YouTube channel, Spotify, Instagram, and just the regular inquiries via phone and text. So we have accumulated a lot of questions per topic that we would like to discuss so that you, as our viewers, will be able to recognize that we are listening and we would like to discuss your interesting situation and our thoughts on how to fix your predicament. So in this episode, we will be focusing on change of name or errors in birth certificate,
Yes.
whether judicially or administrative correction.
Yeah.
Okay. So Attorney Wendy, let's start. I have a bunch of questions.
Okay, yeah. So please go ahead and read those, and I will answer as much as possible.
Okay. So, hi Attorney. My name in my birth certificate has no second name. But in my baptismal birth certificate, it has a second name. I have been using my name with my second name since birth in all my IDs and all documents. How do I correct this?
All right. So, given that scenario, well, actually, that it would be an easy one. Well, I would not say really easy, but for legal perspective, for lawyer's perspective, it will be easy. So, the thing that you can do here for the person who asked is just to file a petition or correction of the change of name before the local civil registry where your birth certificate is registered or recorded. So you will have to include in your petition for the second name and attach therein the supporting documents such as baptismal certificate, which you have mentioned, which included
Second name.
the second name. So along with it are the supporting documents, which are the
IDs.
yes, your identification or issued by the government, as well as your transcript of records, school records, diplomas, if in case you have already graduated, or employment records as well. And an important document as well is the clearance or the NBI clearance, barangay clearance, and the police clearance, showing the second name if you have used your second name in those documents.
And of course, showing that it's clear, right? There's no criminal record. It's not an avenue for you to skirt the laws because
Yes.
you're changing your name and adding a second.
Yeah.
That's good news. How long will it take for that person to change or update his name?
Usually for the local civil registrar, well, by experience, it usually takes maximum of 4 months.
Yeah.
Yeah, 4 months.
So long as you have all the requirements, just like you said, the clearances and all the supporting documents.
Yeah, but that timeline depends on the local civil registry city or the area because it might be different in the province or other cities as well. But for experience by experience purposes, it's just 4 months with us.
Good morning, attorneys. What should I do if there is an error in my year of birth? The birth year is incorrect. Please help.
Okay, for that one, you will have to file a petition before the regional trial court or the family court where your birth certificate is registered, or family court at the place or the city or province where your birth certificate is registered.
Yeah, because the change in the year is material.
Yes, it's not included in the RA 9255 for the correction or the change of name before the local civil registrar. So with this, you will have to hire a lawyer of your own, and then who will assist you with respect to the change of your birth year.
Right. I would like to change the name of my 14-year-old child because he is currently using the last name of his father. I want him to use my last name because we are not legally married and have since parted ways.
All right, for that question, the remedy is for the mother representing the child is to file for a change of name before the family court, having jurisdiction over the local civil registry where the birth certificate is registered. The process needs to undergo a judicial process because this is not covered by the law with respect to administrative process. And the mother needs to prove or give a reasonable reason or reasonable grounds within which why he or she would like to have her or her son or her daughter to change the name from the father to hers. But there is a court decision with respect to that wherein the children or the child is given the option or the prerogative whether he would like or she would like to change the surname from father or the mother.
So how is that? If the child is still 14 years old, that person or that child cannot give a legitimate consent yet. Is
Yes.
it necessary that the child wait until she or he is already 18 years old?
Well, there is a Supreme Court decision with that wherein the court said that the remedy is with the child. So they have to wait, or the mother should have to wait until the child actually turned to 18
18.
years old.
Yeah. Which goes to my question, which is a little bit related to that.
All right.
Okay. Hi, I am an American. I had a child out of wedlock, and now the mother of my child is telling me she is going to change his last name and I will not be able to see him. My son has my last name on his birth certificate. I went to the Philippines to make sure my son had my last name. He just turned 6 years old. Is there anything that I could do to prevent the change of the last name?
Well, since the change of the surname or the last name is, given to the child, well, in some cases, it's the mother who actually represents the child and file the petition before the court. The father will be considered as a mandatory party who needs to be included or impleaded in the petition. So the court will have to require, or the court will require the mother or the child or the petitioner to,
Include the father in the petition to change the
yeah,
last name.
yes. So the father will have to or will receive a summons regarding the case, and then he will eventually notified of the present case, so he can actually oppose if he wanted to oppose or just participate in the case. Instances wherein the child has been born out of wedlock, and then the parties are still together, they made a decision to use the surname of the father, and then eventually the relationship did not work out, so the mom would want to have the surname of their child reverted back to her surname.
Yeah, I'm assuming it would cause issues when they are traveling. The child would have father's surname, and the mom will together that will always be traveling would be using her um, maiden name. And well, while it is possible for the mom to travel with the minor child, it is not legitimate because under the TSWD rules, of course, since the custody is with the mom and the father's consent in traveling is not necessary, still there is a stigma why there is a different
Yeah,
surname
surname.
between the two, the mom and the child. So, what is the takeaway with that? Make sure that you really are going to either get married or you're going to be together for a long time if you really want to put the surname of the father under to be used by your child.
Well, for me, it's like, there's a benefit for the child to carry the surname of the father. So if there are any issues with respect to the parents, well, I guess that's the issue between the two of them. But please, do not include the child as to your war. So he can actually retain the surname of the father because there are tons of benefits with that. So one of that is, inheritance issues.
Yes, it's easier to prove that the child is the offspring of the father because he is carrying the father's surname and there's acknowledgement at the back.
Yeah, that's true. And another one is the stigma, you know, because even though the child is an illegitimate child or a product of a non-marital relationship of the parents, well, there's still, some issues with the child. Why are you carrying your mother's name? So it's automatically saying that you're a product of an illegitimate relationship of a parents. So well, I guess for me personally, it would be beneficial for the child to just retain or even use the surname of the father, even though the parents are not married at all.
But I can see in the questions of our viewers, most of the moms that who are requesting for the reversion of the surname of their child from the father's surname to their surname as a maiden name is mainly because the father is not supporting the child anymore. There's no child support, there's no nothing. They have completely severed relationship, um, contact, and they can't find the father. So the mom feels like, why should the father's surname be used by the son or the daughter if there is absolutely no relationship or no communication with the father? Every single day that you'd see and the
Yep.
child, right, you would remember the father's surname because it's attached to your child's name.
Well, I guess just leave it to the child to select as to whose surname he would want to use eventually, because there are also instances wherein if you're already in the right age, the child is saying, okay, where's my dad? And he would want to be connected again with the dad, even though during the years that he has grown up, he's not together or doesn't even know the father. So I think it would be just be best to give that option to the illegitimate child to use whatever surname that he would want, whether it's the surname of the mother or retain the surname of the father.
I have a few questions regarding changing my last name. I'm an illegitimate child who was born in 1987. I'm currently a dual citizen in the US. I'm currently using my mother's maiden name as my last name in the Philippine passport and other documents from the Philippines, but used my father's last name when I applied for my naturalization in the US. I do not want to change my last name in the Philippines to my father's last name. But from what I've read online about Article 9255 and your blog about it, as an adult, I could just go to the local civil registry office and bring an affidavit of acknowledgement, an affidavit of use of surname of the father. Is that right? Or do I make a petition to the RTC?
All right. So, what was again the name in his birth certificate?
It says that it is under the mother's maiden name as his last name in the Philippine passport and other documents from the Philippines.
And then he changed it to you. He used the surname of the father
When he applied for
for the
naturalization in the USA. I'm assuming because maybe the father is
U.S.
a
citizen.
citizen, that's
Yes.
why he wanted to use a US citizen.
Okay. But how old is he right now? Did he say something about it?
He was born in 1997, so he is already of age.
1997. Okay, 1997. So that is already during the effectivity of the family code. All right. So, well, there is a memorandum, a recent memorandum issued by the PSA, wherein the child, or as a result of a non-marital relationship, can use the surname of the father. Before, it was from March 19 of 2004, wherein the effectivity of the RA 9255. But with the recent memorandum issued by the PSA, it retroacts. They have a retroactive effect at the time of the effectivity of the family code. So what it says there is that the child can actually use the surname of the father already as a result of the out of wedlock
Yeah,
situation. Yes.
yeah.
Mm-mm.
But he said that he doesn't want to use or change his last name in the Philippines to his father's last name. So if he doesn't want to change his family name to his father's last name, then he shouldn't be registering it or recording it with the BSA, with the acknowledgement.
Yes, yes. So if he just want to retain it, so there's nothing to change or correct in his Philippine birth certificate. If he has any issue with respect to the passport or the naturalization that he has applied, then he will have to deal with the country where he applied his naturalization.
Yeah, because when you want to just update your Philippine passport to the surname of your naturalized name. But we did have a client like that, right? Oh, but this one was a change of name in the US, not an update of the family name.
Yeah, no.
Yeah, when you want to have a passport and there are differences there, like there's an updated name, family name or surname because you've gotten married or because of this acknowledgement, you have to present the PSA certificate.
Yeah, your birth certificate.
So for that viewer, he has to choose. Do you want to report your father's last name, but it would cause the updating of your family name in all your papers,
Yes.
or not? And if not, then
Just don't update your birth certificate.
right. My parents were not married, but I used to bear my father's surname till my elementary days. But they changed it into my mother's surname. I want to use my father's surname even though they were not married. It was my father's wish before he left, and I really wanted to use his surname. Is this possible to fix?
All right. That needs to be, qualified, or there are certain questions that we need to ask the person. Well, we need to know exactly if his birth certificate, it was actually indicated the surname of his father,
Mhm.
because if it is, or if the surname of the father is already indicated in the birth certificate, or if the father has acknowledged the child as reflected at the annotation at the back of the birth certificate, then there is no reason for him not to use the surname eventually, after graduation or now that he is an adult, because it already reflected the surname of the father. you know. But then again, he mentioned there that
The school changed it and reverted it to the mom's.
mom's name. Yeah. So our question would be, how did the school was able to change it without asking for a copy of the birth certificate? Not unless the birth certificate does not really include.
The father's surname.
Yeah. So it's really, not clear. The question is not really clear.
Assuming that the birth certificate did not have any acknowledgement from the dad, can the child just go after the dad and ask for an acknowledgement so that he can file for an acknowledgement with a PSA and eventually use a father's surname?
Since the father is already deceased, the child can use an affidavit of document under the PSA memorandum that there are certain list of documents there which he can use.
Okay, so what else aside from those antiquated information or documents that
Yeah.
the illegitimate child can use?
So there's a cedula, certificate of land registration. Well, this pertains to the land title. I guess this is in situation wherein the title is registered under the name of the child, and then the father could be just a guardian.
Mm,
So yeah,
okay.
there's instances like that. And also,
Can also be like a donation stating I'm donating something to this child because he is my son or my.
I think that would be considered as a notarized document
Okay.
also.
Okay.
So those transcript of stenographic notes taken during a hearing by an official court stenographer. So if there is any cases filed in court, yeah,
And he, in passing, would have recognized that this particular child is his, even though he's not yet married to the mom.
yes,
That can be used as an acknowledgement of the father.
yeah.
Okay, what else?
Also, the pleadings filed in court in relation to that case or whatever case it may be.
Correct.
Index cards of the civil service containing data about a civil service employee. So
This can be the,
information with respect to the children.
I think there's the PDS if you're a government employee, right?
Yes.
That you file and you state there who your children are.
Yeah.
Also in your, maybe for example, your SSS, you can indicate there who your beneficiaries.
Beneficiaries. Yes, that could also be used.
Okay.
And all records of the civil register. What else aside from marriage contract, birth certificate, death certificates?
So if the viewer's father is still alive, you can go after the father and ask for acknowledgement. But with his information in the email, it looks like his father is already deceased because it was stated that it's his last wish. So if that's the case, then he has to look into public documents that his father may have um, done, written, notarized that would acknowledge him as a child so that he can use that and file it with the PSA for him to be able to use his father's surname.
Yes.
Okay. I think we have covered a lot, but there are still a lot more questions from our viewers. So we can stop this episode at here and we can have a part two.
Yeah. All right.
Thank you for listening.
Bye.
Bye.